Here are 4 things you need to know when you go to court for a driving on suspended license charge in Ontario. First, you have to go to court. So when you're charged with driving under suspension, the police officer gave you a summons with your court details. Now, these details are going to include the date, the time, and the court when you need to appear. This first court date is called a first appearance. The date is not a trial. The court date is simply the first time you will appear before the court for your drive while suspended charge, and that's why they call it a first appearance, because it's the first time you're going to appear before the court. Now, first appearances are usually scheduled for 4 to 6 weeks after the police charge you, and this time delay allows the police to properly gather all the evidence that they have, and that evidence is going to be included in a package called disclosure, which will be given to you at your first appearance. And the police officer, they're not required to be at your first appearance. Now, if your case goes to trial, then yes, the police officer that charged you will be called upon to give the evidence that she or he has against you, but they will not be at your first appearance. Now, the second thing that you need to know is here's what's going to happen at your first court appearance for your driving on a suspended license charge. First, you're going to meet with the prosecutor and get your evidence. Now, you're going to meet with that prosecutor. Prosecutor's going to give you the evidence, which is disclosure, and that's the package that they're going to give you. Now, your meeting with the prosecutor may be really brief because you're simply just checking in to let the court know that you're there. Now, in some cases, you may have time to speak with the prosecutor about your case. Now, whether there's time or not to speak about your case really is the decision of the prosecutor. Now, after meeting with the prosecutor, you have 3 options to consider for next steps, okay? Option 1, you can plead guilty. Your case will end that day, and most of the time the penalties, whether they're fines, suspensions, etc., those penalties will start that day. That's option 1. Option 2, set a trial date. You can fight the driving while under suspension charge and set a trial date. And option 3 is get a delay, and it's usually 3 to 6 weeks to get legal advice. Now, here's the important point to know. There is no downside to ask for this delay. It's important to understand, and here's why. It's important to understand the charge that you're facing. It's important to get the evidence that the court has against you, and it's important to understand the penalties that you face. And you need that information to take the time to make an informed decision. It's all about making an informed decision. And the last thing that's going to happen, you're going to get a new court date. Now, assuming you did not enter a guilty plea, you're going to appear before a justice of the peace and a new court date will be set. The new court date will either give you time to get legal advice, or that new court date will be to set a trial date dependent upon what you decided to do at that time. In either case, it's important to get proper legal advice to make an informed decision. Third, disclosure is important in your driving while under suspension case, and here's why. The penalties for driving under suspension are really serious. I mean, they're minimum 6-month driving suspension, and that's a mandatory suspension, and all the way can include jail time. And our legal system is designed to give you everything you need to properly defend yourself. And the only way to properly defend yourself is to get all the evidence that the province has against you. Now, once you get that evidence, you can actually see the strengths and the weaknesses of the case against you. When you know the strengths and weaknesses, then you can make an informed decision about how you want to proceed with your case. And if you decide to fight the charges, you can then put together a proper strategy to fight the charges because you have all the evidence. And really, the only way to guarantee that you get your evidence is actually to force you to go to court. In other words, the police force you to go to court to your first appearance, really so you can get the evidence so you can fight the charges against you. The last thing you need to know is, do I have to even attend my first appearance? Now, if you've hired a lawyer, no, you don't need to attend because your lawyer will attend on your behalf. Now, if you have not hired a lawyer, then yes, you're going to need to attend your first appearance. Now, brings up a question, can I have someone who's not a licensed lawyer attend on my behalf? And the answer is maybe. For the first appearance, you may be able to have someone attend on your behalf. However, you should give them written permission that they're allowed to attend on your behalf and include the reason why you're not able to attend. Finally, you should watch the video that's on your screen right now, which is how to make your drive suspended court date go smoothly. There's lots of great info in there. It's a great video to watch. You're going to learn a lot. And finally, if you have any questions, reach out to me. Glad to chat.